Perfect. Well, thank you for having me today. Unfortunately, I wasn't able to travel in person. I was kind of missing out seeing some of the photos. But my presentation today is looking at the use of intellectual property by Games Workshop as a company, more so in relation to their 40K line, but some of the issues, some of the elements would carry over to their other lines and the broader idea of Games Workshop using intellectual property uh, and the enforcement of their intellectual property standards and protections and essentially protecting what is the commercial elements of 40K, the commercial elements of what Warhammer is from a marketable and sales point. So just a brief summary of what intellectual property is, because it is a wide-ranging and wide-reaching concept. Intellectual property refers to the creation of minds, such as innovations, literary and artistic works, designs and symbols, names and images used in commerce, which would be the physical aspects of the products, from the miniature design, from the paraphernalia, from the branded items of paint, to the inclusion of Black Library, Warhammer TV Plus, as well as in new areas where they're engaging with licensing partners in video games and so forth. That IP is protected in law, which enables people to earn recognition or financial benefit from which they invent or create. And this applies to the individual in their individual capacity, as well as a corporation or commercial entity or legal entity that has employees. So in this case, Games Workshop, where they have hired designers, they have hired writers, they have hired sculptors, painters, uh, creators, that they are doing so on behalf of Games Workshop, and they're doing so with the intention of transferring the intellectual property of of the product they create, the model they design, to Games Workshop. And this will be reflected in their employment contract, that the work they do on specific properties would remain and would exist as a property of Games Workshop rather than a independent studio who would later grant permission for Games Workshop to use their product. And this is kind of interesting because of how Games Workshop had previously existed, where Citadel was a slightly separate company where they were selling other products in their stores and their shops before going all in-house. And I'll be touching on a part of this as well, but where there is the copyright, the intellectual property of the creator, is there an obligation to credit them for their contribution, that they are the designer or the artist or the writer, while Games Workshop hold the commercial intellectual property rights because they've commissioned the work? Is there an obligation to credit them, and how that has been an issue in the past, how that is an issue now? And it goes to the idea that striking the right of balance between the interests of the innovators and the wider public interest. The intellectual property system aims to foster an environment in which creativity and innovation can flourish. And arguably that is the early days of Games Workshop, where they were coming out with idea after idea. Some worked, some didn't, but they had this ability to create, they had this ability to work within the system, and then to monetize and protect the ideas they made while building on existing ideas, existing works. And I'll be looking at how you can use existing tropes, existing narrative tools, how Games Workshop have done that to their success, and how they're now in part trying to close off certain innovative elements for others to use similar material. And there's a question of, should they be able to do so? Should they be able to have used this commonality in narrative design, artistic, literary work, and now attempting to close it off entirely because they have been profitable with it and now they want to own it in its entirety. So what we're looking at in intellectual property, there are a number of elements at play, and copyright is one of the first ones. It is the protection of the expression of the idea in a form of media, and it's not restricted to any form, but it is related to the actual expression of the idea. That if you have an idea for a narrative story, if it's in your head, it can't be protected. But if you write it down, the second you put pen to paper, fingers to keyboard, whatever format you're working in, you have expressed this idea. And it's interesting because Games Workshop have taken this issue to the courts before in relation to the Chapter House lawsuit, where it was a question of a conceptual idea was vaguely discussed or mentioned in the wider fluff, in the wider background of 40K, but not actually acted upon. And there was a question of, can a different company make use of these broad ideas, or would they be infringing the copyrighted work of Games Workshop? And it's looking at the idea of protections and copyright for narrative design, character choices, miniature names, and the actual names of characters, where they can be protected, where the work can be protected by Games Workshop or Black Library or their subsidiaries, however the commercial divisions work. It does go to protecting the names and ensuring correct attribution. And it is an issue that was noted in the earlier days of Games Workshop, where the rules were being designed in-house, the art was being designed in-house. There was a requirement and a push by the art side for the work to be credited, for the illustrations to be credited. And if you look at the earlier codexes, the earlier material of Games Workshop, the design teams were fully credited. And this was a push for coming from the artistic side. Filmberg, the YouTube channel, has a few videos where this comes up, that the earlier days there was an attempt to not credit the production team because it was done as a unit, and there was a requirement, there was a query of should they be credited for their work, and somewhere from the artistic, from the visual illustration side, were being credited, and then there was a question of fairness that everyone should. If you look at the books now, it will say designed by Games Workshop with additional material supplied by individuals, and it is a question of are they are the individuals have done the work for Games Workshop, they have created this product, but do they have the moral creativity rights that copyright could also require them to be attributed to? Or can I say I had the ability to work as part of a team on this product? Is that a fair application or not? We also have the question of trademarks, which is the use of icons on name branding, essentially, where the logo or a trademark or an image is associated with a commercial enterprise, and only that commercial enterprise or its licensed users can make use of it. So we have a question in 40K at the moment where there's a shift from Imperial Guard to Astra Militarum. Imperial Guard is more of a generic term, while Astra Militarum is a 40K connotation. It is just for the Imperial Guard of the 40K, even if the fans, the users, the community still call them Guard, the Imperial Guard or Guard. Games Workshop in our official publications will refer to them as Astra Militarum. And we have an interesting application here with the use of Space Marines. Space Marines was a generic term coming from the original Starship Troopers book. There was a question of its popularity with the idea of the Space Marine of an armored space fighter. And we have that as the 40K Space Marines. And there is a question about the branding and the optics of the name, that they are trying to ensure some ability of it is trademarked. And while Space Marines may be a generic term and there is room for debate over its use, the current codexes are Codex Astartes, Space Marines, still attempting to have a trademarkable or protectable term in relation to how Codex Astartes and Space Marines is presented, but still illustrated that they are Space Marines because there's a brand recognition, there's a name weight behind them. And there is a question here about usage and association, the use of common terms or industry standards, that if you're talking about a industry that where Games Workshop is the leading player in the miniature war games maker and hobby, but they aren't the only one. There would be certain industry terms that they couldn't trademark laser gun, but las gun possibly. They couldn't. They may be able to trademark Space Marines that they have for certain connotations, but as a concept, it predates a lot of what Games Workshop are doing. And we see the changing in the naming conventions of certain units, of certain elements. And now you have units rather than just Space Marine Tactical Squad, which is quite generic. You have Space Marines, Codex Astartes Hellblasters, or my favorite of the Nurgle Sloppy Bile Piper, which is such a unique name, but is it so unique that it was just created to act as a trademark that no one else has used it, or no one else will use it, because as a name, I'm not a fan of it. We also have a question of the licensing rights in relation to intellectual property, where Games Workshop will license out elements of its intellectual property to others. And this was something that has shifted over the last decade or so, where they have been more willing and more eager to engage with wider industries and third parties, that they have now a significant portion of their revenue coming from licensing rights and licensing of their properties. We see this in video games with the recent Space Marine 2. We have this with Darktide. We have numerous board games based often on the video games they license out, which are based on the tabletop games. And we have the current Space Marine 2 board game, which is essentially a tabletop game of Space Marines based on the game, on a video game based on the books and the novels and the Warhammer itself. We have questions about merchandising, where this is licensed out, or the official sale, which is conducted as on the Games Workshop sites, where it's sold with third parties or created with third parties rather than in-house. And we also have the potential for a TV show. And I say potential here because I'm sure we've all seen the news of how this is working. But some of the issues in relation to delays of the TV show and the deals with Amazon relate to how the licensing rights account for the intellectual property, who is benefiting, what is permitted under the licensing right. that if Games Workshop license and permit Amazon to use their intellectual property, how far can it go? If Amazon create a new character, can Games Workshop make that character as a miniature? Can they use them themselves going forward, or would they be exclusively tied to Amazon? And the flip side is Games Workshop have licensed the entirety of the Middle Earth strategic battle game coming from the movies in the early 2000s, where we have the Lord of the Rings game, where they license the rights and they have licensed the likeness rights of the actors, which would have been part of the movie deal, where the actors sign on to play the various characters. But they have this license right; it was renewed recently, so they can continue and are making use of licensing from the licensor and the licensee perspective while upholding the intellectual property elements of what they can and they can't do. There's also the growing area of the personality rights, which are a type of intellectual property for the person who may become a public figure, where Warhammer TV or Warhammer Plus presenters were getting name recognition and they were being identified as the person rather than just the person who is an employee of Games Workshop. And depending on the contract Games Workshop may have had with the person, they would have retained their personality rights. That we have seen numerous individuals who were high-profile presenters on Warhammer Plus, Warhammer TV, where they subsequently left because they were not being treated fairly. They were not being compensated for their work. Where Games Workshop have now they've lost some individuals who would have been quite beneficial if they could have had a branding link where we have Duncan Rhodes and the association with Two Tin Coats. That wasn't something that came from Games Workshop directly, but it was an association with him as a person. And in the absence of the employment contract with Games Workshop to include the use of this, he now has a company, the Duncan Rhodes Paint Academy and the Two Tin Coats paint line. At the same time, in an attempt to curtail this going forward, we have seen a shift to the only hands method of presentation for online content, where Games Workshop are removing the human element. They're still providing the content, but there's no question of attribution or protecting the person's intellectual property as a presenter. There could be various business reasons of why they're doing this as well, but it does go to kind of show how Games Workshop have made some errors in relation to their intellectual property for new media. I find it one of the larger areas where there was a question of enforcement that Games Workshop have zealously defended their intellectual property rights, and it is their right to do so. The Chapter House lawsuit relates to a case in the late 2000s where a third-party company was making subsequent alternative or replacement parts, depending on your perspective, for Games Workshop parts, for Games Workshop models. They were doing so as alternative sculpts. They were doing so as replacement parts. They were doing so in some instances where Games Workshop had created a unit, they had created some element of it, but they had not physically created a model. So they were filling in a void. And there is a question of, is that not just the fair market operating, that there is a gap, someone else has exploited it? The question was of who had the right to control that product, who had the right to make use of a generic description of a product. And in the case, neither fully won. The courts held that Games Workshop can't enforce their IP on a model design against models that they themselves never actually make. In this case, it was a type of Tyranid drop pod. I can't remember what the actual unit's called, but it wasn't produced at the time, and because it wasn't produced, but there were rules for it, there was no enforcement against the intellectual property for the creation of that model. It was sold, and it was sold as a generic alien type transport unit, very much in this vein or style of the Tyranid army at the time. It was permitted to be sold. However, Games Workshop won a number of elements where there was over 200 claims of infringement of intellectual property for products Games Workshop had made. That they had alternative chapter badges where they had used chapter logos for Space Marines, which is their number one product, where they were being sold as alternative gendered guardsman or female farseers, two examples, that while Games Workshop didn't make the model, how it was being advertised, how it was being sculpted was so close to the Games Workshop version, it was seen as a infringement. And that's created the issue where neither side fully won, and it has led to Games Workshop changing how they operate going forward, while they're still eager to enforce their intellectual property. If Games Workshop don't make the design, the model, and the rules, you don't have that option. You don't have the ability to use that anymore. partly a result of this, we have seen a shift in the reduction of kit bashing and conversion. There are other metrics and other considerations in this, but this has been a significant impact on how the design philosophy of Games Workshop has gone. Looking at some of the art, it is only art that is reflective of what is physically in the box of the miniatures. And I'm conscious of time, the last few minutes. But there is a question about the further use then of, if Games Workshop is being so zealous about its intellectual property now, can they do so where they've come from a point of infringing or playfully making use of previous literary jokes, tropes, names, references, where many of their original developments were based on historical parodies or historical alterations. The infamous Inquisitor Orlok, Obi-Wan Sherlock Clouseau, flat out referencing three different intellectual properties that Games Workshop did not have a claim to, but it was part of the overall canon at the time. In the first Eisenhorn, in one of the Eisenhorn books, he flat out has a lightsaber. While they don't call it by name, is it infringing the intellectual property of now Disney, or is it just a reference to a laser sword? But everyone knows it's a lightsaber. Is that a question of generic terms in an industry of sci-fi? Is it a question of fair use or homage, which would have certain protections, where they're not the leading aspect, they're an incidental or passing reference? Or even the use of conference titles, where Games Workshop would have the copyright on the line. In the grim dark future, there is only war. Yep, sorry, there's a hand up. Am I out of time?
No, so if I may jump in, we started a little bit late, and I even was late as the moderator for that session. So thanks for starting already. But I guess you can come to an end in 1-2 minutes, and then we can come to the question and discussion.
Yeah, I just have one last slide after this. Just on just looking at some of the conference titles, we have used similar titles that if we were publishing these as commercial publications, we may not have been able to use that title because we're directly referencing this. And it is a question about Games Workshop having a right to protect its intellectual property. But there is a question of how far should they go before they run afoul of targeting honest fans who are doing a fan publication as opposed to an infringing third-party commercial entity. So that's just me just on the last bit of the titles. Thank you for the time.